in that case, such a new state, one that has already implemented the entire acquis communautaire, these negotiations could be rather straightforward. Of course, this then also begs the question of whether a possible Rest United Kingdom veto of Scottish EU membership could be regarded as illegal under the EU legal order, an issue which might be interesting to explore another day. It should be highlighted that the court does, like many domestic courts, have a tendency to maximize the application of its own EU law. For example, in the recent C-420/07 Apostolides case, the judges concluded that a regulation limiting the application of the acquis to southern Cyprus could not be used to block a judgment concerning property lying in northern Cyprus. The Saar case is also a good example in question. Although the formal treaty recognizing the change in the European coal and steel community, mostly formalities, was not ratified by several member states for several years, the practical application of EU law was never called into question, given that EU law in the region applied even before the Saar was returned to Germany. James and Alan's opinion is that the question whether a state is a member of the EU is hitherto been treated as a matter of international law, citing Commission President Barroso, just as the question of territorial extent of the state has been, citing Hansen and Hauptzoll on Flensburg. This is one place where certain nuances might be helpful. While I do not argue that they are wrong, the legal situation of overseas territories is perhaps more complicated than a unilateral decision by one EU member state, as seen by the many works on EU law of the overseas. Differing perspective, these bothersome nuances, also become clear in the question of EU membership of the Eastern German Länder in 1990. As noted in 1991 by Thomas Gierig on East Germany's integration into the European communities in the Heidelberg Journal, I quote, "The Commission, however, assumed that the automatic extension would be affected by a norm of community law not further specified. Thus, it was not compelled to deal with the question as to whether and how far the present international law of succession recognizes the principle of territorial flexibility. Since all the member states, as well as the GDR, were agreed on the mode of integration, the international law problem simply did not arise. Of course, we may hope that for EU lawyers, international law might come to be seen as more than simply a problem. But if accession is governed exclusively by EU law, there's a strong indication that, for instance, withdrawal from the EU of a European territory of a member state could also be governed nearly entirely by EU law. To conclude, as an EU and international lawyer, I support the direction of James's and Alan's intellectual project in this opinion. It underlines the importance of negotiation and the principle of loyal cooperation, which is applicable to all parties in this case, and is to be applauded in the sense. While the nuance that I've attempted to signal in this brief commentary might further strengthen it, their overall conclusions are probably not wrong. In any event, they're certainly useful for an informed public debate. Thank you very much.
Thank you. I'm going to focus on a caveat that the opinion mentions at paragraph 167 and also at paragraph 184. Namely, at paragraph 167, it is acknowledged in the opinion that the rights of all current EU citizens might lead the European Court of Justice to take a different approach, i.e. not judging the effect of Scottish independence purely on the basis of international law alone. And at paragraph 184, the opinion says, and this is an important caveat, that this, of course, would only affect the position of Scotland within the EU legal order. But that would matter a lot for Scotland. So leaving aside the questions which I think have been very comprehensively addressed in the opinion of the effect of Scottish independence under international law, such as admission to the United Nations, let me focus on two questions. The first one is Scottish membership in the European Union. Now, I agree with the opinion that the United Kingdom, the rest of the United Kingdom, would likely be regarded as the continuator state of the UK as presently configured. Scotland is unlikely to be automatically a member of the European Union, though I do think, and I think on that point the opinion is perhaps more pessimistic about the probability of the European Court of Justice becoming involved, that if the Court of Justice were to be confronted with a question about the effect of Scottish independence, it would also apply European Union law. The Vienna Convention on the Succession of States in Respect of Treaties, to which the opinion refers, in Article 4 refers back to the internal law of the international organization. Now, there are some questions whether the convention applies to a structure such as the European Union, but even if it does, there is a reference back to the internal law of the international organization, even if that law is perhaps silent on this question, and even if there is no precedent. The Court of Justice is likely to apply also European Union law. Now, what I found particularly interesting about the opinion is that there is a distinction. The analysis differs with respect to the European Convention on Human Rights. So the European Convention of Human Rights, the prediction is likely to continue to apply in respect of newly independent Scotland, even though Scotland would have to re-accede, the opinion says, to the Council of Europe. Now, I think it is quite likely, in the case of Scottish independence, that Scotland, assuming that Scotland would have to apply for EU membership, fundamental rights guaranteed by the European treaties and the economic freedoms under the treaties would also apply based on similar reasoning to all those who currently benefit from them. So I think in this respect, and again, I think here the Court of Justice is likely to become involved at some stage, and at a stage where it still matters for the outcome. In this respect, Rockman-style arguments are likely to come into play. The Court of Justice of the European Union is likely to be reluctant to deny the benefit of fundamental rights and economic freedoms guaranteed by the treaties to all those who currently enjoy them as a result of a reconfiguration in the political setup of a European Union member state. And I think international law itself on the question of nationality has been changing, certainly in the 20th century, as a result of the human rights revolution. There is increasingly a shift away from an identity conception of citizenship to one focusing on rights. And the European Union legal order has gone further still in this respect. Writing more than 80 years ago, the Harvard research in international law, looking at nationality in international law, said the following, and I quote, "The meaning and import of nationality have changed with the changing character of states. It, that is nationality, may acquire a new meaning in the future as a result of further changes in the character of human society and developments in international organizations." What better example than to think of the European Union? And it is difficult to see how the Court of Justice would not take this into account if it were to decide cases involving Scottish independence. Thank you.
Well, thank you very much. It's fantastic that the question of Scottish independence is being debated by an Austrian, a German and an Australian. Is there anyone from the Rump UK who might want to make a contribution to start with, or indeed anybody?